We have the copyright bill that's on the president's desk. What should you do with it?
You mustn't sign it.
What's the capacity of the creative industry to contribute towards the growth of the economy?
Currently, post-COVID and with all the challenges, it's at 3% contribution to the GDP. In the last 2 years or so, I don't know how many big productions have been filmed in South Africa. They're going to other countries where the law is clear, where they can do things like consolidate rights because they know what's going to happen. They know what the rules of the game are.
Welcome back to Palatable Politics, a show where we take the complexity out of politics and make it palatable for you. With me, your host, TJ Maslela. Welcome to the show. In today's session, we're going to be going into the copyright and also just understanding copyright, the role of SAMRO, and that whole industry, the creative industry as a whole in SA. And here, to make it palatable for us, is none other than Ms. Chola Makgamathe, who is a chairperson of Copyright Coalition in SA, the general manager of legal services at SAMRO, an admitted attorney, and you also did your master's focusing in law and a lot of law, cyber law, intellectual property, and telecommunications.
Yeah.
Welcome to the show.
Thank you for having me, TJ.
So I've highlighted your CV on Google.
Uh-huh.
Can you tell us a bit about who you are and what your journey's been?
Sure. As you said, my name is Chola Makgamathe. I am an attorney by profession, not a practicing attorney, but in-house attorney for SAMRO, which is obviously in the music industry. I have been in the music industry for the last 14 or so years, and I got into it by accident, actually. I had just had my first child, and I'd taken time off from practicing law to focus on her. And after spending a year with her at home, I thought, I need to get back into the market somehow. And a gig came up through the Department of what was then Arts and Culture. Now it's DSAC, Sports Arts and Culture, sorry. And they had, through the National Arts Council, purchased Downtown Studios in Johannesburg. Downtown Studios are historic recording studios and have a particular place in the political history of South Africa because a lot of who we term our legends recorded their music there. It was owned by Gallo, which was the oldest independent label. A record label in this country, and they then sold it to government because government had wanted to have particular interventions in the music industry because there were issues of access to things like recording studios, proper productions, post-production, those kinds of things, and there wasn't a facility that, in particular, the youth of this country could access at an affordable price and produce good music because there was a proliferation of a lot of home studios, and at the time when I joined, obviously the home studios were not producing the quality that some of them are producing now, and the big studio environment was needed for certain productions. You still do need a big studio environment, and they had bought that asset, and they needed a lawyer to help with some of the issues pertaining to the transfer of the assets, dealing with the employees, and a few other issues. I was supposed to be there for 3 months. I was there for 7 years.
Okay. Yes.
Very interesting, very complex. I was behind if you go there now, the newly renovated studios, changing of the branding, all of that. I was there for all of that, and then this opportunity came up to go into SAMRO, which obviously is a very niche area. Copyright administrator in the music industry, and I took that, and I've been doing that since. And whilst I was at SAMRO, I have been quite actively advocating for proper copyright legislation, because currently the Copyright Act is being subject to a legislative process through the Copyright Amendment Bill, and we have been advocating for that piece of legislation to be fit for purpose for not just the music industry, but the creative and cultural industries, CCIs, what we call them, as a whole, because the way it's currently drafted would be very, very detrimental to the CCIs, not just to the music industry.
Let's take a step back. Copyright Coalition in SA. What is it? How did it come about, and its objective?
So, as I said, the Copyright Act of 1978 and the Performance Protection Act are currently subject to an amendment process. This process has been going on for over 10 years. And we, as the culture and creative industries, had been making submissions to the Portfolio Committee in Parliament about various issues or various aspects of the bill. We then found that the NCOP in 2017, I believe it is, then introduced or then passed a version of the bill that had introduced this concept of fair use without proper consultation. And I'll get to what fair use is a little bit later. But as a result of this, we were then forced into a position where industry had to now come together under one umbrella to form a coalition of sorts that would speak for various sectors within the CCI. So this would be music, and within music, you've got publishers, you've got collective management organizations, you've got labels, you've got the creators themselves. So that would be just music. Then also in the book sector, you've got the book publishers, the book authors. Adjacent to that, you've got script writers who would also be within the audiovisual sector. So our members also consist of organizations there. So we as collectively decided to form the Copyright Coalition of South Africa so that we could make submissions as a unit and also as individual sectors so that they could be taken seriously by the policymakers and the legislators. Hence, the Copyright Coalition was born in 2018 and has been advocating and participating in the legislative process since then to ensure that we have a bill that is fit for purpose.
Now, coming into the Copyright Act, what is it in its current form? And then I guess we'll come to linking it with the performance protection.
Okay, so basically copyright is a form of intellectual property law. You think of it as a house with pillars, right? You have a house and the roof is what we call intellectual property law. And then you've got pillars. You have trademark law, design law, patents law. You have copyright law as well. And copyright is very niche compared to the others. The others are heavily, if you look at how the legislation is drafted, very clear, very regulated, very concise in terms of what is required for things like registration, what it is, time periods, those kinds of things. Whereas copyright, not so much. Copyright law basically is the regime that governs the balance between the right for creators to create works, so whether it's to write a book or write a song, and do so with the ability to make money out of that for that work, and also on the other end the rights of users to use those works, but also do so in a manner that is fair to the creators of the works, but promotes access and other things for users. Because ultimately, people need information. They need to be able to use information, either to create other things or to do whatever it is they need to do it. But you need to be able to use that information in a manner that's fair and compensates and acknowledges the creator of the work. So it's supposed to be about maintaining the balance between the two and giving the rules of engagement as to what works are protected under what circumstances, how they're reproduced, how users must use those works, under what circumstances, they must receive licenses, the penalties should they not do so, and also it includes what we call copyright exceptions. So the normal rule would be if you write a song or you write a book and I want to use it, I must ask for a permission, get a license, pay you a license fee, and then you ultimately get royalties.
If I want to use it for commercial purposes,
yeah,
or just use it
for commercial purposes. That's the general rule. Right. But there are exceptions to the rule, and these exceptions are called exceptions to copyright. It's what happens across the world in all jurisdictions where there is copyright law. You have the rule, and then you have the exceptions to copyright. And they fall under broad umbrellas. Some call it fair dealing, like we do in our legislation. There's also fair use in other legislations. But with fair dealing, what we have currently is a closed list. So you have the rule, and then you have the exceptions. But the exceptions are clear, and there is a closed list of exceptions. So you would know that if I'm using your work and I haven't asked you for permission, which I mean, I would generally approach you because there are moral rights that accrue to copyright, to say, look, I want to use your work, whatever the case may be. And if I'm not paying you, for instance, I want to use it for satire, for news purposes, and even then, depending what purposes, for educational purposes, etc., etc., those are the exceptions. Those are the times where I don't necessarily have to pay you a license fee for it. And we know. So it's like I use a sports analogy. analogy. If I know, if we're playing a soccer match, right? We know when there's a penalty. We know when it's a free kick. Whatever the terms are, we
And
know.
VAR.
Yeah,
There's VAR that regulates
we
us.
know.
But
We
yeah,
know this
okay.
is it, right? And if something happens, we are able, or the referees be able to say, oh, that's a free kick, that's a penalty, etc. etc. That's how it is currently. Now, what we find very egregious, broadly speaking, the amendments. Now I'm getting to the amendments. The amendments to the bill are problematic. Broadly speaking, it's a dog's breakfast. It was really poorly drafted. But one of the most egregious things that has been introduced into the law is this concept of fair use, and not just standard fair use, but broad fair use or hybrid fair use that's introduced. So currently you have a soccer match when we all know what the rules of the game are, when it's a fair kick, free kick, whatever else, the penalty, etc. With this introduction of fair use, what they've done is that they've taken a closed list of exceptions and used the words such as. So you never know under which circumstances your works can be used without you necessarily being remunerated for it. So it opens up the door for users, particularly big tech users, to use works, to use songs, to use books, etc., at will, without compensating the creator of the work. And then if the creator of the work comes and says, hang on, you're supposed to pay me, you're infringing my copyright, they can say, oh, well, it's fair use, take me to court. So sports analogy. Imagine playing a soccer game. You never know when it's a free kick. You never know when it's a penalty. You just never know. And every time the referee needs to make a determination, the referee must run off to court with both parties to determine what the thing is.
So essentially, the referee is the judge.
Yeah.
Okay.
Yeah. Or there's the umpire or in the game, and then they take it to a judge, and then the judge in every instance, right? So for every instance of alleged infringement, the judge must make a determination. So it's man-made law. So you never actually know what the rules of the game are. You know the rules of the game with that particular set of facts. That's how the law operates. You apply it to that particular set of facts and what that particular judge said about that particular set of facts. And then you understand what that is. But that game has been played, right? So the next game, you don't know what the rules of the game. Let's all run off to the judge again. And this country is not a very litigious country for various reasons. Maybe because of we're not like America, who've been litigating for hundreds of years. It's expensive.
Yeah.
The average creator, to pay a lawyer, 1,000 Rand an hour just to go and tell your story, and then all the paperwork and the court processes, that's very, very expensive. It's prohibitive to the average creator. And also what is also appalling about this law is that we've imported it from the US. And in the US law, they have what we call punitive damages. So for instance, if we go to court, you take me to court and you say I've infringed your copyright and you win, you can get punitive damages. You can get millions, or you can have a class action and get millions. Whereas here, the way it's drafted currently is that if you take me to court and you win, you will get what you would have gotten had I paid you the license fee to begin with. So if your license fee is 10 Rand and you have to spend 10,000 Rand in legal fees, what you get at the end of it is the 10 Rand I would have given you, or I was supposed to have given you to begin with.
So I understand what you're saying, kind of, right? But when you say that we took it from the States, which is, we have this perception of Hollywood and all the rappers and everyone's got money and well paid, treated. Would it not be ideal then to use that as a framework? And if not them, then who should we have modeled our copyright?
So if you look at it objectively, better option would have been an Australian model.
Okay, which is?
They also have fair dealing there, right? Most countries, most jurisdictions have fair dealing. In the US, fair use even there is not necessarily working. But if you go and just Google fair use litigation, America, you're going to find tons of it. Because that's the number of instances where people are claiming fair use of your work and you have to go to court to prove that there's been an infringement. So that model for us doesn't make sense because we need to have a level of certainty in our law. Plus, remember, for them, they've been litigating on this thing for, like I said,
So there's lots of case law.
there's lots of case law, there's lots of precedent, there's lots that can guide them. They're more advanced from that perspective than we are. And even at that, they're still struggling with making case law, it's judge-made law on the issue of fair use. Whereas if you have a closed list, particularly for a country like ours, if the list is, we all know what the rules of the game are. Anyone who wants to stray, you can easily say, this is what it is. But if you introduce something that has so much uncertainty, the lawyers will make all the money. The lawyers make all the money.
You guys.
Yes.
You in your profession.
They'll make them, well, not necessarily me because I'm not practicing, but the lawyers will make all the money. You creatives will be in court all the time. Collective management organizations like SAMRO would be in court all the time because part of our job is to be the middleman between the creator and the user. We license the users on behalf of our creator members. They pay us a license fee. We process the data. We get an admin fee for that, and then we pay out royalties. Now, if we try and license someone, which is already happening, and they say to us, no, but this new law that's coming in is gonna give me the defense I need to use your members' works, then we have a problem. Then we'll be spending all our time and members' money in court trying to defend their rights, which is what our mandate is. So lawyers all round making lots of money.
You mentioned that one of the issues is that they put such as. What should they put that would make it more?
They should leave the list as it is. I understand.
Okay.
You need to, because of the way works are being used, it's changed. Part of the reason why they're amending the act is because you need to bring it into this century, into this decade. It's an old piece of legislation. The usage of works has changed. We've had a blow up in the digital era. So things are vastly different from when that piece of legislation was drafted, and things are constantly changing. I mean, there's AI, there's just a lot happening in the creative space right now. So we do need to have legislation that's amended. The problem is that you can't just go and make changes that are not going to make sense for South African creatives. So leave the list as a closed list. If we need to expand the exceptions and keep it closed, then that process is there. It's determined by international standards. It's there in the Berne Convention and international treaties, which determine how you include exceptions to the law. There's what we call a 3-step test, which I'm not going to go into here. Mm-hmm. But basically, it's to protect the rights of the creators. And if the exception meets the requirements of the 3-step test, you can introduce it into the law. And that can be done at ministerial level. In the current act,
so
those powers...
regulation.
Yeah, those powers are given to the minister. That can be done. But to go and try and introduce a piece of legislation that will basically decimate the creative and cultural industries just doesn't make sense.
So at the time of recording this interview, the bill is on the president's desk.
Correct.
The desired outcome is that he doesn't sign it.
He mustn't sign it.
And then the changes be done through regulation by the minister's powers.
No, because remember, regulation is subservient to the main piece of legislation. Okay. So we would still be stuck with the problems in the main piece of legislation. Because remember, I told you that legislation is a dog's breakfast, right? It's poorly drafted. And part of the reason why it's a dog's breakfast is because it assumes that the creative and cultural industries is one thing. It's monolithic. It assumes, and because they're probably the loudest, that the cultural and creative industries comprises of the music industry, which is untrue. And that's how they've drafted it. They've treated music the same way as the way audiovisual sector works, and they work completely differently. They've treated music the same way as animation. They've treated music the same way as book publishing. They've just gone and done this one-size-fits-all approach to an industry which is very diverse. It has got various sectors and subsectors. It's got various value chains that intersect at different points. It's got various ways of using rights and monetizing rights, but they've acted as though it's one thing. And I think a huge part of that is an ignorance of the sector or the industries within the culture and creative industries itself. So And the challenge with that is that I don't know how much of an understanding the legislators within the legislators within their portfolio committees have of the culture and creative industries. I don't know if they understand that it's more than just singing and dancing. I don't know if they understand that it contributes 3% to the GDP, which is on par with agriculture. I don't know if they understand how
With a
much.
lot more potential.
Yes, with a lot more potential. If they understand, like, for instance, the AV sector, how much foreign direct investment that sector brings into this country.
AV?
Audiovisual, sorry, film and television.
Okay.
I don't know if they understand how much investment that sector brings and how much employment that sector creates. Because when you see a film or a TV program, I don't think they understand what goes into that. I don't think they understand how many industries are supported, from accommodation, food, production, actors, actresses. There's set
Makeup.
builders. There's music. There's a whole lot that goes into that. And recently, South Africa became a hub for international production houses to come and make movies here because it's beautiful. The Cape Town's beautiful. Probably you get more bang for your buck if you're bringing your euros and your dollars here.
Yeah.
So there was a lot of investment from those production houses in this country. But this legislation has made them very nervous. Now they're going to, I don't know, in the last 2 years or so, I don't know how many big productions have been filmed in South Africa. They're going to other countries where the law is clear, where they can do things like consolidate rights because they know what's going to happen. They know what the rules of the game are, right? So now they're pulling out the investment and they're looking at investing elsewhere because of things like this piece of legislation. So it makes it very difficult to operate in South Africa.
Okay, wait. So let's say you have a HBO or one of those international companies. They come, they shoot their content produced here in SA, but they are American actors, American company. How does that legally work? Is it our laws? Is it their laws? Who owns that?
So if you're talking about the IP, if they need to use local IP, then our laws will apply.
Okay.
Right? In that instance, there are different productions in how they operate. So you might find an American production house comes here, does everything, but they still use the services of local companies. So they'll still use the facilities. They might use they might subcontract some work to South African companies, whatever that is. I wouldn't know. It depends on the production. They would still need to use local catering, local accommodation. They'll still need to use various local services in order to have that production here. That's in the one instance. In the other instance, they will then maybe fund local production houses to make local productions that will go on their platform, say, for instance, a Netflix, and obviously their distribution deals. So it's a very complex, it's not a simple thing, It depends on the nature of the production house, where it is, what IP they need, what services they need. There's just a whole lot that goes into that type of thing. But whichever way you slice it, if people are making films here, there is a benefit to some area of that sector. It might not be all of it for a particular production, but there is some direct investment into the country.
The Copyright Coalition, I say. At what point, what would need to be done for you guys to say, okay, tick, our job's done, mission accomplished?
Firstly, the president mustn't sign the bill. And I know I'm raising a lot of problems, but we do also have a lot of solutions to propose to the president regarding not only the CCIs, but how to tackle this bill. Sorry, culture and creative industries.
Okay.
But how to tackle this bill, because it's sitting before him. It has to a large extent tied his hands in terms of what he can do legally, constitutionally, etc., etc. We do have proposals for him in terms of what can be done there to ensure that we salvage this situation. Because what would happen? I mean, you can see with the other things, like there's a huge uproar about NHI, but that's something else. And he's got quite a few bills sitting before him where there's a lot of dissatisfaction. But for our purposes, we know where the pain points are for the president in terms of taking this forward, and we do have solutions for him. So first, he mustn't sign it. Secondly, he must meet with us so that we can tell him what the solutions are, propose the solutions to him, because we've made an investment in securing those solutions, and we're able to say, have a look at this. This is what you can do. This is what you're allowed to do in terms of the constitution and the law and all of that. So for us, it would be reset, redo that just
So from his side, he can just not sign and they can start the process again.
No, unfortunately, because it was passed through the National Assembly. That's why I say it limits his options. Him not signing means that he has very few options. because this is the second time round. Remember, he sent it back before, eh?
Yes.
Sent it back before with very serious concerns, which were not dealt with, in our view, appropriately, because we still have this dog's breakfast of a bill. And now they've gone through the process again, and it's sitting with him for a second time. Now, when it happens like that, he should either sign or refer it to the Constitutional Court to determine the constitutionality of the issues that have been raised or that still remain that we would raise. So if he doesn't sign it, he can't just say, I'm not signing it, I'm just going to not do anything. He has to do something. So it's either refer it to the Constitutional Court, or we were hoping, in terms of looking at what the Constitution says, be able to refer it back to Parliament to see how it's dealt with. But there are challenges there, because the very same department that has been mucking it up for the last 10 plus years would still be the department that would be responsible for drafting it. So we're not going to get much joy there in terms of having a bill that's fit for purpose. Would rather have it be dealt with by DSEC, who is responsible for the cultural and creative industries. I know there's the whole trade issue, blah, 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 which is why it's sitting with DTIC, but they don't understand it. And clearly that's why we're here.
Okay. All right. Let's hope for the best with that. SAMRO.
Yes.
What does it mean?
The Southern African Music Rights Organization.
Okay.
Is what we call a collective management organization. And it's one of many.
You touched on it earlier, but just to refresh us, what do they do? And let's start with what they do, and then we'll come into the nitty-gritties.
Okay, so remember I said the Copyright Act is about managing the balance between the creators of works and the users of works.
Yeah.
And within the Copyright Act, there are different types of works that are defined. So you can have a literary work, you can have a musical work, you can have a sound recording. There are different types of works depending on the sector that's involved. And each one of those works can be exploited in particular ways by users, but you must get a license in order to exploit those works. What we do is that we administer, which is a fancy way, we're the middleman, like I said before. We're the middleman between the user and the creator for the performing right in musical and literary works. So, when you write a song, there are certain rights that accrue to you as the creator of that work. So think about flowers in a vase. Think about the vase as the song, and each of the flowers being the rights that accrue to you in that song.
Okay.
And we call those a bundle of rights. So that's a bunch of flowers in the vase. So the vase is the work or the song, and the flowers are the individual rights that accrue to you. Each one of those flowers represents an opportunity for you to make money. It's a revenue stream. And for each work, there are different rights. So for instance, for a musical work or a composition, there would be what we call public performance rights, which we administer. There would be mechanical rights, which this organization, Capasso, administers. And that's upstream for the composition. Now what happens? So the composition is the arrangement and what's written by a composer. And then further down, when it's reduced to a sound recording, there are copyrights that accrue to the sound recording. And that's administered by another CMO, two other CMOs, SAMRO and IMPRA. And then there are other rights, for instance, sync rights, which if you affix the music to, you put on a video or film. Okay. You can make money from there, right? There's money to be made from the labels, Risa Rev. So in that vase for that one particular song, each one of those flowers, there can be 10 flowers, 20 flowers. Each one of those flowers represents a revenue stream for you. And that's just one work. And SAMRO administers one of those flowers, the public performance right. So we are the middleman between those who want to use your... So for instance, restaurants, stadiums, streaming platforms, retailers, salons, like for commercial purposes. All of those people, we are the middleman between our members who are composers and authors and those people. And we license them, and then we pay over a royalty to our composers and authors based on the usage of their works. So in order for you to make money, somebody must use your works, which is why you maintain the balance. But to use your works, they must pay you, right? Now, if they're not using your works, you're not going to get paid.
Naturally.
And a lot of people say, no, I won't mention names. SAMRO is not paying me. Yeah. And you're like, okay, let's go see. When was the last time? Yeah, when's the last time your stuff was used? Right? So we are supposed to pay you zero from where? Or money from where? If there's zero from zero, we can't pay you. So it's a function of usage. I think a lot of people don't understand that. In order for you to get paid for it, first of all, you must be our member, right? You must notify us of your works, because a lot of people will write a song, go to studio, etc. They won't tell us. They won't notify. Drop it. It's big, SAMRO. But we go to our records. When did you notify us? You didn't notify us. So you need to be our member. You need to notify us for all the works. Because what some people do is that they go and they become a member. Some don't notify at all. They think that's done. Some will notify maybe the first work, and then they won't come back for the rest. And in your notification as well, you need to be able to tell us what the splits are. So, for instance, people will go to studio, right? It's nice, right? They make a banger. But you don't discuss there and then who's getting what percentage of what role did so and so play. And even in that, there are different roles that you play. So what's your split as a composer? What's your split as a performer? Because that split as a performer is administered by a different CMO. We deal with your rights as a composer, author. So like if the three of us contribute, what's my percentage? What's your percentage? What's his percentage? You go notify and you won't give the splits properly. Or what some people do is that they'll go notify and then they will give themselves a larger split than the others. So when we pay, according to information you've given us, that's how we pay you. And what tends to happen is that people realize they're not making as much money as they should, and then they lodge a complaint with us, and then we put the monies in suspense, and then we deal with whatever the claim is with regards to that work. But there is work that needs to be done by the actual creators themselves in order to earn the money that they believe is due to them.
Okay. Now on the practicality, because as now you get a stadium, right? Sports game, whenever the Boks play, there's, what's that song they play every time? Is it Mandos?
I know it's something like that.
Yeah, okay. So every time that plays, he's supposed to get royalties or paid off of that because, obviously if he's a member and has complied. Likewise, if one is in a restaurant and they're playing that music, that restaurant is supposed to, it's a restaurant, right? Mm-hmm. That's supposed to pay royalties to you guys, and then you guys would pay the artist, whether it's a vocalistic or...
So we enter into what we call, so we don't enter to license agreements that are per use license agreements, because that's difficult to administer. Okay. We give you what we call a blanket license. So legal terminology, we indemnify you against any claims for the use of our members' work. Yes, basically, it's insurance. We're saying to you, you are paying us. Nobody can come and make a claim against you. You've entered into this agreement. You have permission. You're paying us this amount, and you should give us the usage report. So still send us the usage reports. We have a particular formula that we use to calculate all of those things in the background, which then spits out a rent figure depending on what the usage is, and then that is then paid over to our members. Don't ask me the technicalities of that formula. Our distributions guy is better placed to do that. But essentially, there's work that goes in the background to process that data in order to give you a figure. So it's not per use. But if your work is on, they use the term in radio, high rotation, you will make more money than somebody whose work isn't on high rotation. So ideally, when they play that song, and you see, now I can't even remember the name. It's going to be stuck with me. I'm going to try to figure out what the name is. So, they should be, because it's used so much, it should equate to or translate to ultimately a certain level of earnings, either for the composer or performer if they are alive, or to their estate.
But going back to fair use. So if they played it for less than 30 seconds, it would mean that there's no royalties. Under the amended.
No, if they played it for whatever amount of time and they said it's fair use, doesn't matter.
Okay. Right.
That's what I'm saying. They can just go to town.
Okay.
You
So, and then the compliance now, both from event organizers and from creatives themselves, where's it sitting?
Creators are an interesting bunch because a lot of them are unaware of what their rights are.
And not administrative.
Yeah, they unaware, they're not, which is why they rely on the likes of SAMRO to help them, which is all well and good. It's getting better. So for us, like I said, it makes it difficult if you're not notifying your works, if you're not a member of SAMRO, if you're not giving us the right banking details. I don't know if you've seen, we had to beg at some point. Please give us your banking details.
You can give them mine. You can give them
Right?
mine.
So we can pay you things like it's data integrity issues. If you you register a song under one name and then they as records with another name, or changing the name of a song slightly, or registering the same song with slight changing, it makes it difficult to, we call it match the data to what we have in order to pay you appropriately. So from that perspective, the creatives need to do a lot more work or get people to help them to comply, which is why a lot of them have publishers who can help do all of that admin for them. But it does make it difficult if the data that we have is not good. We can't pay, we can't find you, we can't pay you, wrong banking details, etc., etc. From users' perspective, so there's a shift. There's a shift because obviously the economy is tougher now. What we are selling, the product we're selling, is a grudge purchase. A lot of people don't understand why. Why the restaurants will be like, why?
Yeah.
I'm playing off my whatever Spotify or whatever. Why must I
I'm playing
pay?
with my phone. Yeah.
Why must I pay you? And said, or some others would be like, no, I've paid SAMRO. Why am I paying you? So there's also a lack of understanding of the entire rights framework, and the understanding that, like I said about the vase and the flowers, each flower, is administered by a different CMO, and you need to go and comply with each one for the different rights and pay them a fee. So there's a lot of that, and I think there's just a lot of, with this uncertainty in the legislation, chance takers now who are saying, let's see what happens if this fair use thing comes through, what we'll do, and depending on who you're dealing with. So if you're dealing with a big corporate who understand compliance and they've got risk registers and they want to be good corporate citizens, they'll comply, but the issue becomes the quantum. So how much must I pay? What's the value now of what I'm paying for? So you have that conversation. Or you have the others who will be like, take me to court. Let's see each other when we have an outcome in 5 or so years.
Okay. So in closing, what's the advice you would give to a creative that is coming in, that's already there, that's to protect and advance themselves?
Understand your power. Understand that intellectual property, in particular copyright, is the basis upon which you are going to make money in this industry. That's how you're going to exploit the works that you create. A lot of them get excitable and they just sign things, right? For odd periods. Be careful what you sign. A lot of them get excitable and they get these huge advances, and cars, and get excited by silly. No, just
now you owe 50 albums.
Yeah, keep calm. Understand what you're reading. If you can't, try and find somebody who can help you understand it. Because what tends to happen is that they get these thick documents with lots of legalese that they need to read through, and promises of fame and all of that, and they just sign. And you find yourself in a situation that you can't get out of for quite a while. You're not making the money you think you should be making, and it becomes difficult. So just understand the power that you have in owning your IP and exploiting that IP. And if you need a third party to assist you, make sure that you structure those agreements in a manner that's fair to you. Also, try and understand your industry, or get a manager who understands your industry, because people are just letting money go for free everywhere, right? And I know in our industry there are a lot of gatekeepers. There's a lot of hoarding of information, so people don't know where to go, how to make money, etc., etc. I think try and understand the industry. Read, the information is out there, guys. It's I know sometimes it's a bit complex and it needs to be broken down, but it's out there. Read as much as you can. Be as informed as you can. Understand who the players are. Understand the value chain. Understand how you can make money, and take it from there. Otherwise, you will not. Yeah, you will struggle to survive in the let me just say the music industry for one.
Okay. Thank you for making time and making that education and how people should find out palatable.
Yeah.
So thank you very much.
Thank you for having me.
Guys, thank you for tuning in. Please don't forget to like, subscribe, share. Tune in, same place, same time next week. Palatable Politics.